Hi everybody, I'm Mike, this is Budget Guns and Gear Reviews, and you are watching an excerpt from The Right of the People. If you want to find out how to watch an entire uncut episode, stick around to the end. But until then, maybe we'll learn something together. For those of you who may be new to the show, this is The Right of the People. We go over the news of current events that have happened in the Second Amendment world during this past week, and we talk about it in amongst ourselves here in the panel and with you in the chat. So feel free to chime in, ask questions, make suggestions. If I'm not on it, one of the guys in the panel will be, and they'll let me know. So, this is a conversation between all of us. So the first thing we're going to talk about tonight is a while back, we talked about the Young versus Hawaii case. And that's a case where George Young in Hawaii had been requesting, which is absolutely horrible that he has to, been requesting permission from the state of Hawaii to have a concealed carry permit and has been denied over and over. The thing is, the state of Hawaii hasn't issued a concealed carry permit in about 10 years. They don't do it. And they also prohibit open carry. Well, in the Peruta versus San Diego case in California, the Ninth Circuit Court ruled that concealed carry was not protected under the Second Amendment, and which was odd because that case wasn't about concealed carry, but they made it about concealed carry. Anyhow, when the Young case made it to the Ninth Circuit, a three-judge panel ruled that since concealed carry was not protected under the Second Amendment, open carry was, and that Hawaii had to allow open carry. Well, as you can imagine, the state of Hawaii stuck to their guns, and they appealed that, and now it's going to be heard before an Banc panel. This is from Reuters by Jonathan Stemple, U.S. Appeals Court to revisit open carrying of guns. A federal appeals court has decided to reconsider its recent decision that the Second Amendment of the U.S. Constitution protects the right to openly carry guns in self-defense. In an order on Friday, the Ninth U.S. Circuit Court of Appeals said it will revisit whether Hawaii acted lawfully in denying the plaintiff, George Young, a permit to openly carry a loaded gun in public. Circuit Judge Darmoud, and I'm sorry for butchering that, Darmoud Scanlon wrote for a 2-to-1 majority last July 24th that we do not take lightly the problem of gun violence, which the state of Hawaii has understandably sought to fight, but that the state nevertheless violated Young's rights. The dissenting judge, Richard Clifton, said the Second Amendment was mainly concerned with protection of hearth and home, and that disagreement among appeals courts about its reach meant the U.S. Supreme Court might need to weigh in. Friday's order means an 11-judge appeals court panel will rehear the case. A hearing has yet to be scheduled. The Ninth Circuit has jurisdiction over 9 western U.S. states, including California. It is widely viewed as one of the more liberal federal appeals courts. The composition of the Supreme Court has changed, and it means the Ninth Circuit will have to be very careful in evaluating the merits of Mr. Young's case, Alan Beck, a lawyer for Young, said in a phone interview. My client has made it clear he wants to keep fighting as long as it takes. Hawaii officials did not immediately respond to requests for comment. The July 24th decision came 2 years after another full Ninth Circuit panel found no right to carry concealed guns in public, overturning a ruling also written by O'Scanlan. Last month, the Supreme Court said it would review a New York City law imposing strict limits on the ability of handgun owners to transport their guns outside their homes. A ruling, which might not come until 2020, would be the court's first in a Second Amendment case in roughly a decade. It would also be the first since Justice Brett Kavanaugh joined the court in October, likely bolstering its 5-member conservative wing. The case is Young versus Hawaii, 9th U.S. Circuit Court of Appeals, number 12-00336. What I think is going to happen, and I would bet pretty much everything I own, that the result of this 11-judge en banc panel is going to be that they're going to overturn the present decision in which the lower panel, the 3-judge panel, said that open carry was then if you're not going to allow concealed carry, you have to allow open carry. That's going to be overturned. And my hope is that Mr. Young seeks and is granted cert before the Supreme Court, and they can finally rule on this, on the whole open carry, concealed carry. Is carry outside the home absolutely protected? Which I believe the McDonald case said it was. So this should be interesting. Now, there are people that have said, well, they didn't take the Peruta case, which the Supreme Court didn't. However, there were a couple differences between the Peruta case and the Young case. In Peruta, because California, and from what the common understanding is, they didn't take the Peruta case because California does, while it forbids open carry, it does allow concealed carry in some places. In California, you can get a concealed carry permit if you're in a gun-friendly county, because it's up to the local chief law enforcement officer whether or not you get it. So that's why they denied cert in the Peruta case. But with this one, you can't open carry unless you're engaged in the business of life protection, as they phrase it, a security guard, police officer, etc. And they don't issue concealed carry permits ever. They haven't issued even one in the last 10 years. So we'll see how this goes. Thoughts, guys?
This, to me, is it's a fight worth it, definitely. I think it's a good battle. Glad that's going to the court, but for where it is, I'm not sure it's going to be a winnable one. The left coast, Hawaii, it's pretty unfriendly territory, but we have seen surprises out of there. So I think that instead of betting everything we own, I think we should actually just wait and see, because sometimes we get some interesting rulings.
I would be very surprised if they didn't overturn this.
I was under the impression that Hawaii is may issue. They just don't honor that.
Correct.
Not that they're shall issue, they're may issue.
Correct.
And if California is may issue and they use that before, then I don't know that this is going to go anywhere. Because they go, well, look, we are may issue. And,
yes, but they're may issue, but they don't issue, and that's the problem.
I know that, but what I'm saying is through the legal trickery of these lawyers and all these other people, they go, well, on the books we're may issue. It doesn't matter whether they do it. You know what I mean? How underhanded some of these guys are.
Sure, they're going to try that. And they may even issue a permit somewhere between now and then just to try to deflate that argument.
Yeah, and that could be something, they release one, right, just to... So sometimes you got to anticipate some of these things, how they'll flip something, they'll turn it on you. I would like to see them have open carry, permitless open carry out there, just so that they've got something. We'll see how it goes.
My prediction is bad news all the way around.
You think it'll get overturned and SCOTUS won't take it?
Well, I'm just talking about the courts for the en banc court that's gonna see it now. Yeah, getting to the Supreme Court is where it's gonna have to go, but I don't think that the court that's gonna have it now. I think that they're gonna say that you can't have a gun outside your house.
Oh yeah, absolutely.
Like, period.
It's the Ninth Circus. They're going. Excuse me. They're going to overturn it. I don't think there's any question on that. The question becomes, will the Supreme Court hear it? And that's what I'm hoping happens, because we also, another thing to consider with the difference between this and the Peruta case is the court's different now. We have some different justices on it, and they may decide to take it. They may be wanting to take some more Second Amendment cases. Alan Gottlieb from the Second Amendment Foundation said on Armed American Radio not too long ago that he thinks the floodgates are about to open with regard to Second Amendment cases with the Supreme Court. So, and he's pretty dialed into this kind of thing. So I'm hoping he's right. Hi everybody, I'm Mike. This is Budget Guns and Gear Reviews, and I'd like to thank you for watching this excerpt from The Right of the People. If you like what you saw, please like, share, subscribe. If you really liked what you saw and would like to listen to the entire uncut episode, you can do that one of three ways. You can either be a patron on Patreon, a contributor on Gunstreamer, or a channel adopter on CocoScope. Thanks, and come on back. Maybe we'll learn something together.